On this episode of the Houndsman XP podcast, we are bringing you part 3 of Don't Shoot My Dog. Don't shop on Facebook for legal advice. We're bringing it to you right here on the Houndsman XP podcast. And in this third episode, I am bringing you a prosecuting attorney who went on to be the Assistant Chief Deputy Attorney General for the state of Indiana. He's now in private practice. Aaron Negengard is who I'm talking about, and I sit down with him, and he is going to give you step-by-step legal procedure on how the legal system works. It has been my experience as a professional law enforcement officer that the most frustrating part of the criminal justice procedure is the uncertainty of knowing what is actually going on. Aaron is going to walk us through step by step and tell us what is actually going on with a criminal case from cradle to grave. After this 3-part series, there should be no misunderstanding that justice is available should you go through something like this. Another benefit is when you hear of this happening, you are going to know someone that this is going to happen to. If you've been in hounds and hunting very long, you will know somebody. You can give them a resource to draw on. Houndsman XP is available. I'm more than happy to talk to houndsmen that go through this and assist in any way that I can. And that's why we do this podcast. This isn't an entertainment piece. This is a piece that is going to help you be successful in one of the most trying times you will ever experience as a houndsman. Folks, we're going to get with it. The Old South Dog Box is rocking. We've got a good episode for you. Let's get the tailgate down. It's time to dump the box. Rolling, so we can just kind of fade into it, but we are in this is the southeast side of Indianapolis, and I'm sitting down with my longtime friend and Aaron Negengard. Aaron, you and I have a history together as far as our professional paths. You were my prosecutor.
Yeah, for a long time.
How many years were you the prosecutor in Dearborn County?
So I was in the prosecutor's office since 1997, and I became the prosecutor in 2006, and I left in 2017 to go to the Attorney General's office.
Yeah, and you were up in the Attorney General's office for the state of Indiana until...
For 4 years, and then end of December of last year, I started my own private practice.
Yeah. So you've been on both sides. What kind of practice are you doing now?
Well, I do criminal defense and family law, and then I also do some civil litigation. I've taken some interesting cases. I'm pretty much just like your normal small-town attorney. If someone's got a legal problem, I try to help them through it if I can, or direct them in a direction of someone who can help them.
So you're to sum up your career, you spent did you go to the prosecutor's office right out of law school?
No, I was in private practice for a little bit, and actually in '97 I was part-time with the prosecutor's office. Shared one position came open, so it was split into two. The other person you recall is Tony Sabo, and then we were part-time for a while, and then we eventually became full-time. When I was in part-time, I still had a private practice. But obviously not in the criminal defense world. So I did, divorce and bankruptcy. I was a school board attorney for a year. A couple of years. I was a county attorney for a year. I was on county council for a period of time. And then in 2000, I became the prosecutor in 2006 by appointment from the caucus because Sally McLaughlin, who left to become judge at Dearborn Superior Court 2, and she was appointed by Mitch Daniels for that position. She was appointed for a year, then ran that same year, and I was appointed for a year and ran that same year, and then I was elected. And then I never had an opponent, so I was elected 3 times and became, when Curtis Hill was elected Attorney General, went to be his chief deputy for his term of 4 years.
I felt really important when you got that job, just so you know. I had a link to the Attorney General.
There you go.
But yeah, I mean, we worked through a lot of different cases.
Yeah.
And Dearborn County is a pretty busy place, and you established a pretty good reputation down there as a prosecutor and things like that. So I'll tell you, one of the reasons why I wanted to have you on the podcast was to talk about, I remember it was cool for me to see the prosecutor of my county, where I worked most of the time, bring his kids to the Hoosier Tree Dog Alliance youth hunts at Crosley.
That was great.
And get involved in hunting like that. And it was an unusual thing for me because I'd never had a prosecutor that I really thought gave a crap about what we did, other than making sure our paperwork was right and how you could pretrial things off the court docket. But
right. Yeah, well, my kids were, I grew up, my grandpa was a big hunter, and my dad tried to do it, but he was too busy, and so he and I never got to experience that very much. So I wanted to make sure my kids had the opportunity to hunt if they wanted, and so we did all kinds of different types of hunting. Squirrel hunting with tree dogs, I mean, was a blast. I mean, you just can't beat that. And I mean, we were out there, I think, on that particular hunt, it was like below zero.
It was cold. Holy smoke. We thought about canceling that one.
It was really cold, but we had a blast. I mean, you get moving, you're not as cold. And that's the fun thing about that kind of hunting. And then, of course, I went deer hunting a few times and took the kids. My youngest was not much of the deer hunter. He couldn't sit still in the stand very well.
Right.
But he kind of enjoyed it. But my oldest, he could sit in the stand for hours without getting bored or anything like that. So he was a bit more successful at it. And, it was just something we did as a family and had a lot of fun with it.
Well, I think having that exposure is so valuable for you to be able to talk about this topic. You see, you've got to interact with the hunting public, especially with tree dogs and houndsmen, to see what kind of passion and between me and David Snyder and Jacob Jump and some of those guys in Lawrenceburg Police Department, how passionate we are about that. And then you got to go out and experience that with us and see that. It made you I was really appreciative of you getting involved at that level.
Yeah, well, it was a lot of fun, and Jacob has since taken me and the boys out for rabbit hunting, and that's a lot of fun too.
Yeah.
Now, I'm not a very good shot, as I'm sure they would tell you.
Jacob already told me.
Yeah.
No, I'm kidding.
Well, I'm sure he will if he hasn't. But it's fun. We had a great time rabbit hunting. And of course, rabbit's pretty good. So
yeah,
it makes a good stew.
Well, we are going to talk about dog shootings.
Yeah,
particularly hunting dogs, and my goal for this portion of the podcast is to help people who incur this type of incident, this type of tragedy in their hunting life, how they can do things to stack the odd in their favors, to make sure that they get good, successful prosecution for these crimes, and also recoup civil damages in civil court. And let's just start. We're going to talk mainly about Indiana because that's what we're both really familiar with, but I know other states in the country have got very specific laws to deal with criminal loss. But in Indiana, if a person has a dog that is shot, and we can just start with generally dogs being shot, let's talk about that a little bit.
Okay, so it is illegal to shoot a dog. It's certainly one that's not your property. So there's a couple different. There's shooting a vertebrate animal that they could be prosecuted under. It's also destruction of someone's property, so it could be criminal mischief. And it could be, depending on, most hunting dogs are pretty valuable, so it can hit the threshold to make it a felony. So those are the options here in Indiana that I would imagine are similar across the country. And so those questions, of course, all depend on the facts, right? And that's where those cases are decided, is how, first and foremost, it's the investigation, and does the investigation show the facts? I mean, as a prosecutor, I was always concerned with what the evidence showed, right? I mean, people can get caught up in following an emotional side, and that's not your role as the prosecutor. Your role as the prosecutor is to look at the evidence, and what does the evidence tell us about the facts, and do those facts support a criminal charge? And as a prosecutor, I always wanted proof beyond a reasonable doubt, because that's ultimately the standard. Can it be less to file a charge? Yes, but are you really doing your job as a prosecutor if you're filing a charge you don't have the evidence beyond a reasonable doubt? And so I felt, since that was the standard, we lived by that standard. And I mean, we were very effective still in pursuing prosecutions. Now, I never had an instance specific to this type of case, but that's what does go on, and as prosecutors look at cases.
Criminal law is criminal law. The threshold for, proving beyond a reasonable doubt is the same whether it's somebody breaking into your house or somebody
That's correct.
stealing your gun out of your truck or somebody shooting your hunting dog. Is that
correct.
accurate?
Yeah, it's all the same standard. So, you can file a charge based on if you have probable cause, which is not a very high standard. But sometimes those charges will get filed, but as a prosecutor, what I'm looking for is what does the evidence tell us? What does it show? And is that evidence beyond a reasonable doubt that a crime was committed? And if the answer to all those questions is yes, we file the charge, and then we pursue it to try to get the best result. And obviously, there are cases that aren't perfect. No case is ever perfect. There's always issues with cases. So you're not looking for perfection, but does the evidence tell the story that there's proof here beyond a reasonable doubt that the person is guilty? And if the answer to that's yes, then we can pursue it. And then sometimes when you're negotiating a result, you have to consider the victims. You have to consider, we always try to make a point to talk to the victims about a plea. In fact, it's required under Indiana law to do that, to check with the victims. So we would check with the victims, make sure they were okay with if we were going to have a resolution by an agreement, make sure the restitution was accounted for, and those types of issues.
Well, let's clarify here. So when you talk about a resolution, you're talking about a plea bargain.
Yes.
And what's the goal of describe for our listeners what the purpose is of that plea bargain? Because I think a lot of times it gets thrown around and bannered around, even in the media, that plea bargains are, I'm sure they'll reach a plea bargain in this thing. Right. They won't even get a conviction. So explain the value and the detractors from reaching a plea bargain.
So, and what I always call it a plea agreement, because it's not necessarily a bargain. And I can tell you, I probably
good point.
I probably prosecuted a number of people who weren't at all happy with the plea agreement and didn't consider it a bargain. So the question is, you want to try to resolve things by agreement, because when you don't, there's a lot of costs associated with it. A jury trial, even on a lower level offense, is expensive. The jurors have to be paid, people have to be brought in, they have to be fed during this period of time. Most juries don't result in hotel stays, though. That's like big bigger, high-profile cases where they have to be protected from the media circus. And, I had a lot of cases, but we never had one where we had to do that.
Mm-hmm.
But that said, it's still expensive. You have your deputies, you have a lot of costs associated with it, and it's a very time-consuming. It takes up a huge chunk of time, so you can't afford. It would bankrupt the system if every case were tried.
Mm-hmm.
So you look for a reasonable resolution. Now, again, depending on the strength of the case, the resolution could be not anything at all that the defendant wants. I mean, because the defendant has to weigh, if they go to trial and push it, they could get the max.
Mm-hmm.
And the max could be a problem for them, right? I mean, what do they want to risk going to jail if they wouldn't otherwise be going to jail? Do they want to risk, they have to consider a lot of risks too. And I can even tell you on the other side, the prosecutors, they have a lot of leeway. I mean, I've had cases that I've actually wanted to go to trial, but my client has said no, they'll take the offer because they don't want the risk.
Mm-hmm.
So both parties have to consider the risk and the cost. I mean, the prosecutor has to take into account the cost. And so you have to come to an agreement because it just wouldn't function any other way. But for the most part, what the parties do is work out a resolution that's somewhere close to probably what would have happened had you gone to trial,
Mm-hmm.
right? Because the defense attorney's looking, okay, what's the judge likely to do? The prosecutor's looking, what's the judge likely to do? And you try to reach something that we can all agree. And the benefit to the state generally is that there's an agreement. But sometimes it is you're just pleading to the court and your client's throwing himself on the mercy of the court. But it is a mitigating factor if you take responsibility. Just like anything. I mean, the courts are always going to consider if you did mess up, if you take responsibility, they're going to look at that as a mitigating factor.
Mm-hmm.
And so when people take responsibility for their actions and own up to their mistakes, certainly that's a mitigating factor that needs to be taken into consideration. And so many cases, that's what people do even after talking to an attorney because it's going to benefit them to do that. And so that's why most cases end up in a resolution. Now, oftentimes, bigger cases don't. Like murders aren't going to get resolved because there's no happy ending. Certainly death penalty, there's no middle ground there.
Right.
A person's not going to agree to go be executed. Although I think McVeigh tried to. But that said, I think it's important to understand that the plea agreement system is something that's vital to keeping our criminal justice system working, and it's not really bargains. I mean, look, sometimes the cases don't work out and the defense gets a pretty good deal. Oftentimes, it's the other way around.
Right.
And so I would say it's a system that works pretty well.
And so it's not like the prosecutor looks at a case, and I'll just talk through it like this. Okay, I'm the one that responds as the officer.
Mm-hmm.
Like I would go out to the scene and investigate. I would put all my findings in a report, turn that report into you, and then we'll talk about that process in a second. But then you have to evaluate the merit of that case based on my report and things like that. And at some point, the plea agreement isn't simply a way for you to say, hey, there isn't enough here for a prosecution, so we're going to plea this one out.
Right. No, and in fact,
because you have no leverage. If there isn't a case, there isn't a case, right?
Right. So if there isn't a case, we're not going to file it.
Right.
I mean, that's where we assess the case. Now, look, there's some cases that are better than others, even if they meet the threshold, right? I mean, if you got a full confession and you got video of the crime, I mean, depending on what the circumstances are, that puts you in a superior negotiating position.
Sure.
Because the case is really, really strong. So even when you meet the threshold of beyond a reasonable doubt, there's still relative levels where you still have really strong cases and maybe not so strong cases. but that doesn't mean you don't pursue it if you have a good faith belief that there's sufficient evidence to prove beyond a reasonable doubt that the person committed the offense. A lot of those are sometimes on when you have a single witness who saw something, but you find the witness credible, and the jurors have to believe that witness.
Mm-hmm.
Well, as a prosecutor, if I believe that witness, then I believe there's an evidence beyond a reasonable doubt. But that doesn't mean that with a single witness, without much physical evidence, that I have a strong case.
Mm-hmm.
So, there's a lot of prosecutors have a lot of discretion, and, they have to make those decisions on a daily basis about what to pursue and what not to pursue. And sometimes those decisions are tough, and sometimes the toughest decisions are when not to file a criminal charge. Mm-hmm. Like, something very bad could be happening, but you choose not to file because you don't have enough evidence. I think we've seen in cases at a national level where prosecutors, do the politically expedient decision, and that doesn't always work out because they did the political expedient decision and no one should have been prosecuted because there wasn't enough evidence. But they did it, because they wanted to look like they were on top of it. And so, and I'm glad when that doesn't work out for the prosecutor who made the political expedient decision instead of the right decision. Mm-hmm. So there's a lot that goes into it. And then also you considering the nature and circumstances of the crime, right?
Right.
And so some crimes are obviously worse than others. So you try to determine, like a lot of conservation type issues we did a pretrial diversion for, like not hunting without a license as an example. Well, it's not fair to every hunter who's paying those fees to hunt. I mean, I know I paid the fees. Right. So when someone wasn't hunting without a license, but is it something that they need the criminal conviction for, right? If they have a financial consequence that's higher than what would have been had they, and they have no other criminal history, right, then that's something that would be appropriate for a diversion. Now, if they do it every year and every year they're getting caught, then we have to look at a different resolution. The point is to change that behavior, right, so that they don't do it again. And that's the point with all of it. But as you get to like murder and child molestation, you're not so concerned about whether they change their behavior and whether they stay in prison and pay the price for those levels of crime. So you have a wide spectrum from speeding tickets to murder.
I think there's a lot of misunderstanding out there about like the levels of crimes. When you take, and I'm going to be showing my age, but when I started, it was A through D felony. So you take something that's a D felony, that means something to me as an officer, and that means something to you as a prosecutor. Whereas, murder was an A felony. The dog shooting deal in the state of Indiana is if a person kills a vertebrate animal belonging to another person without that person's consent, it's a level 6 felony. Bang, there it is. Okay, now the defenses behind that are if it's showing a risk to personal safety, destroying your property, those sorts of things. So just saying that, well, it's a felony to shoot a dog doesn't mean it's a felony of the same level as, selling crack cocaine to school kids on school grounds. It can't be. And when I'm very attached to my hounds and my dogs and stuff like that, but for me to think that crime of shooting my dog rises to that level is unrealistic for me, or for me to have that expectation that it should be that important to our society and to the prosecutor's office. Right.
And I would say, but one of the things I would encourage your listeners, if they've ever experienced this thing or if they ever have the unfortunate circumstance where this does happen to them, is that they do communicate with the prosecutor's office.
Good point. That's where I wanted to go.
Because, look, now I understood as a prosecutor that a minor offense, so-called, was not as significant to the big picture as, say, a murder case, right?
Mm-hmm.
But by the same token, a minor offense, and some of those level 6 felonies or Class D felonies, you and I are both old, remember the Class D felony? I've been, back in it for a little while. I'm finally getting used to saying level 6 felony, but the first level of felony, right? The lowest level felony, a Class D or a level 6 felony. But a lot of those are very serious crimes.
Mm-hmm.
And if they rise to that level, it should be taken seriously. In the sense that, I wanted to have my office make certain we were attentive to the victim and attentive to, because that case is very important to them.
It's the biggest thing going on in their life.
Right. To them, it's very important.
Yes.
And so I wanted our office's response to that to reflect that we understood and appreciate and not get blown off as, hey, this is nothing. Because at the end of the day, we're public servants and we're there to serve the public, and they're a victim of a crime, and they deserve to be heard as to the significance, because it generally is the most important thing, even if it's a level 6 felony or a Class D felony. Yes, and so it was important that we dealt with that. And I had, even as prosecutor, some cases where I was involved in the level 6 felony, even taking it to trial, because it was the facts were so egregious that I wanted to make certain it got that level of attention. So I think it's important that in this situation, one of the things is a lot of prosecutors in Indiana may, but many prosecutors don't have any experience, don't understand the hunting world or the value of a hunting dog or the amount of work that goes into training a hunting dog and what that loss means, right? They're just like, okay, what is it I got in front of me? So it's important, as we were talking about communication, it's important that that person who's the victim, that you get with whichever prosecutor or the victim advocate, who's ever responsible for communicating with the victim in that office, that you communicate with them by phone, by email, whatever's necessary, whatever's allowed, so that that office understands how important this is to the person, to you, the victim. Because if you don't communicate that, they'll make the assumption that if I'm not hearing from anybody on this, then it must not be that big a deal.
Right. And while I said what I said a minute ago about it, there are other things that aren't as important as that to our culture. It is the biggest thing going on. If one of my dogs gets shot, that's the biggest thing going on. And that type of person does not want to feel like that their value is any less than any other victim out there.
Exactly.
And so let's talk about that communication a little bit, because a lot of people don't understand all the different working parts of what's going on there. You mentioned a victim's advocate.
Yeah.
So what is their job in the prosecutor's office?
So now, obviously it varies, right? I mean, in Indiana, right, the prosecutor's offices vary in size from very small to very large, right? If you look at Switzerland County Prosecutor's Office, which is, in our old stomping grounds, right, versus the Marion County Prosecutor's Office, right? I mean, there's just two entirely different worlds, right?
A lot of difference between Vivi and downtown Indy.
Yeah, and the population's different. But, so you got basically two prosecutors, and so, your chief deputy's handling the minor consumptions that came in that weekend versus, that's not being handled by the chief deputy of Marion County.
Right.
And then those are like opposite sides of the spectrum, and you have everything in between. Mm-hmm. So the communication is going to vary depending on what type of office how large the office is you're communicating with. And, what you need to understand, but every office has a victim advocate. And if it's a larger office, they should have more than one victim advocate.
Right.
And that's the person who's responsible for communicating, because under Indiana law, and a lot of states have these requirements, It's actually under the Indiana Constitution, we're required to advise victims of the hearings and keep them posted as to what's going on in their case. And so it's a constitutional obligation in Indiana for the prosecutor's office to notify the victim of what's going on. And sometimes it happens really well, sometimes stuff falls through the cracks. And so what we're talking about is how do we make certain that what can the victim do to make certain that this is handled appropriately by the prosecutor's office and doesn't fall through the cracks of a bureaucracy, which all prosecutors' offices are. So the victim advocate serves a role as they're supposed to be the one in communication with the victim. They send out the initial letters, they get the feedback. So, all prosecutors' offices should be sending a letter out that says, okay, this is this case, you're the victim in this case, please send us your information. Mm-hmm. Now, if you know that that person's been arrested and had a hearing, it is okay for you to initiate that conversation with the prosecutor. You don't have to wait to get your form. And you can contact the prosecutor's office, and I would follow up. I think it's important to follow up everything with an email, and that just confirms. I mean, if you just have a phone call and someone talked to you and they didn't document it.
Yes.
Yeah, so I always think it's appropriate. The phone call's fine, and in fact, a good thing because you want to have a working relationship with the person. But by the same token, you need an email as a paper trail. In the old days, you just send letters. But in this case, you just send an email. Oh, I appreciate talking today. Here's what and you can politely say what you discussed and stuff. So if there's ever a question down the road, you could sit with someone superior and say, here's my email on such and such date, such and such date, such and such date. And that helps. And look, the squeaky wheel does get the oil. You don't want to be overly squeaky because it may, I don't want to talk to that person again. But you want to be persistent enough so that they understand how important it is. So, because they're not going to have any clue. I mean, most deputies are not going to have any clue how important it is that someone's hunting dog got shot. And they need to know. And the best way to do that is if you could schedule a meeting, an in-person meeting. It's harder with COVID, or at least a Zoom call, something to where they can actually see you interact with them, preferably with the deputy who's in charge of handling the case, because that's the person who's actually going to be making the decision. That can't always happen. And doesn't always happen, and that all depends on how the prosecutor's office handles those things. So at least with the victim advocate, because at a minimum, the victim advocate's going to be communicating with the prosecutor who's handling the case. And so that prosecutor is going to take into account what the victim advocate's telling him or her. And I will tell you, look, one of the most important things for prosecutors handling the cases is not to have upset victims. We don't want a victim coming in at the sentencing hearing and telling the judge, I'm not in favor of this plea. Now, because the victim has a right to do that in Indiana. Now, that said, there are times where people are unreasonable and unrealistic. Now, as the prosecutor, I always wanted to make certain if we were going to be in that situation that we've sat down with the person and explained that to them exactly what's wrong with the case, and I never had those conversations really go bad. I would have, even after I had those conversations, people might express a little, still might go into the court and say their piece, and that's fine. At the end of the day, the judge is probably going to defer to the prosecutor if the prosecutor shows that they were diligent on this issue and there's a reason for the plea. Now, if that said, I know, pleas do get rejected when a prosecutor, contact with the victim has been poor.
Yeah. So today's day and age, you talk about that phone call. You get a phone call from the victim's advocate, and I'm on my cell phone, and I'm out hunting.
Right.
I haven't got anything to document with at that point. I don't, unless you're really on it,
Right.
Carrying a notebook and a pen with you, you're not going to be able to document that. So you say anytime you have a case like this and then you get contacted by the office, you should ask for an email address to follow up, to come back and say, hey, do you have an email address that we might be able to communicate on? And it's just simply an email back saying, thanks for your call today. I appreciate you taking time to talk to me, even though they're obligated to do it. It's called greasing the wheels here a little bit. But it's my understanding that this is what we covered today. You told me this, and this. Is that accurate?
Yes. And I mean, if you are in a place driving or whatever where you can't, and this conversation takes place and it's going to be followed up later, you can always just say, if it's a few hours later, get the email address, and you can always call back and get the email address when you're at a place where you can write.
Right.
Or you can, if you have the email address, a lot of times it's on the website anyway, you can shoot an email and say, thank you for your time. I was driving at the time, didn't really understand. What do you need from me?
Sure.
And again, and it's okay to take that opportunity in the email again to express, the value the dog has, because that's.
I was going to ask you about that.
Yeah.
How do we come up with a realistic value for that loss?
So what you aren't going to get is like so what you get so restitution in Indiana and in most places deals with more a direct out-of-pocket loss. Okay, so a lawsuit might be a little different. A civil lawsuit, you might get a little bit more. You can argue about other things, but actually, so the value is the fair market value of that animal.
Okay.
Because look, I mean, obviously dogs have a personal, emotional attachment, but that doesn't get taken into account when a veterinarian commits malpractice generally, and it doesn't really get taken into account. At the end of the day, from a legal perspective, a dog is an animal. Is a piece of property, and that piece of property has a fair market value.
Okay,
if it's an exceptional dog and would sell on the market for X, then it's X.
Okay, so this would be a typical thing. All right, I'm out coon hunting with my hound. It ends up getting shot. At that point, I've got a hound here, and this is just examples. Say he's earned $10,000 in lifetime earnings in competition hunting. It's a male dog. That'll be the easy one. And his stud fee is $500. And what sort of things can I bring together to help us establish a value for that hound?
So is there a market? I mean, is there, like with cars, right? You can determine the market for cars, putting the relevant information in on cars, and it gives you an approximate price.
This isn't NADA. So we don't have any blue book.
You don't have a blue book. I mean, is there anything like that, though? I mean, are dogs with those types of credentials sold on the open market, or do people generally hold on to those dogs?
Both. It can be either way.
Now look, in a civil case, you might be able to get lost earnings from competition. You might be able to get that in a civil case. So in a civil case, it might be, because you can attribute a specific number to that. But legal restitution is more limited than that. It's limited to an out-of-pocket loss. So it would be limited to, from the criminal perspective, your restitution that you'd be entitled to would be limited to what that dog would go on the market. And that can be a range. Now, that doesn't mean you undersell that to the prosecutor, right? I mean, you put all those facts in because the prosecutor's going to get kickback from the defense attorney. What do you mean I got to pay X amount of, I looked online and I can get that dog for X, right?
Right.
And so you're going to have those debates. So the more information the prosecutor has, the better. And one, you're dealing with a negotiation of a criminal resolution, so they may tend to pay a little bit more, to satisfy and get it done.
So that he doesn't have so that your shooter doesn't have a felony conviction,
as an example.
And he's losing several other liberties that are.
Well, if he gets a felony conviction, he's not going to be able to hunt.
Right.
So, at least for a period of time. So that obviously is of some value. So you do have the ability, as long as there's good faith. It doesn't mean you get to pump up the value of your dog more than the value of the dog. But so the more information you give the prosecutor with regard to that, the better. And also, I think it's important that the prosecutor understand the emotional attachment hunters have to their dogs.
I think that's a big...
And that's just so that they understand how important it is. It's not just a money thing, although money is certainly a key component.
Sure.
But it's not just a financial loss when a dog is shot. There's an emotional plus... a lot of people will actually hold on. I mean, some people train dogs to sell them up, but some people...
Sure.
It's they're not giving that dog up.
Right.
Right, that's their...
And the situation that I can think of that playing more of a role in is like when my teenage daughter, when she was a teenager, would hunt with me a lot. If it would have been one of my dogs that would have been shot like that, that would be a lot different for me to pursue that case than if it was my daughter's dog, because she looked at that dog in a completely different way than maybe I did or I do. And so now I'm dealing not only with the loss of this hound, but I'm also dealing with the emotional loss that my daughter is experiencing at that time. So I always say, you said loss of hunting, but what kind of human being would shoot another kid's dog?
Right.
I mean, come on.
Well, and I think that goes into consideration. I mean, look, the prosecutor's office is certainly going to consider all those factors. And by the way, they're going to consider, because the judge, if it were just like an open sentence, the judge would consider all those factors. And it may be that the facts are particularly egregious. That there's really, whatever thought went into it, the person was just callous and just shot this animal without thinking twice about it. And then, and that this animal happened to be, a kid's dog that has, all those factors. So it's important to communicate all that. And now, look, not necessarily in the sit-down conversation if you can't get to all of it. But that's why it's important that it all be communicated in email.
Okay, so boiling this thing down, and we'll just, I might be a little facetious in some of this, but if a person goes through an incident like this, should they be on Facebook scrubbing pictures of their kids with their dog? Should they be gathering information on fair market value for, and it varies. So say I've got a 2-year-old or a 2-year-old hound that has already won X amount of dollars, and I project him of winning this much more. I've also bred 3 or 4 females, so he's proven himself in the breeding pen. And what all should I be putting together in this package for you? So all of that stuff, or should I?
Well, if you have an idea what the fair market value is, that would be a good place to start.
We're still talking criminal. We're not talking civil.
That would be a good place to start. And then, that information would be, okay, so here's the fair market value. Here's how I arrived at the fair market value. Here's other facts should be taken in consideration. And what the animal's earned. How much projected lifetime earned. You could put all of that in. It doesn't mean the prosecutor's going to sit there but it gives and say, okay, I'm going to give $10,000 more than the fair market value. What it means is when the prosecutor says, look, I need X, because that's what we've calculated as the fair market value, and, he or she should talk to the victim to determine, to come to an agreement is, well, what do you think, you're entitled to? And
it's priceless, Aaron. It's you can't.
And if you tell them that, then you're going to get less, because the prosecutor, it's not priceless. Emotionally it might be, but that can't ever be paid. So you got to come up with an actual figure.
Yeah.
And you have to come up with a figure that's in good faith, defensible.
Mm-hmm.
And that's defensible by facts, right? Here's how much that dog would go on the market. Now here's how much that dog would go on the market, presumably takes in lifetime earnings and all that stuff. But if it seems high, then those facts help solidify its value, right? Versus a dog that hadn't earned anything yet and hadn't been a stud fee, right?
Right.
But it still costs something to purchase that dog. And depending on how far along it is in training, its value would be increased. So, that dog has a fair market value, and then you do your best to try to determine it, and then you fill in those facts to support that. And if the prosecutor has that when he's meeting with defense counsel, or she's meeting with defense counsel can have those facts when their client says, "Well, there ain't no way that dog's worth that much."
Right.
Well, this is the information I got. What do you think? What do you think it's worth? And then maybe we negotiate that. But the more information, information is key. The more information the prosecutor has about the case, the better resolution the prosecutor can achieve. Because if the prosecutor doesn't know any of that stuff and is calling you the day before the plea hearing with, what do you think the value is? You're not likely to get as high a value as if you had given the prosecutor all the information.
Okay, so taking into consideration that you're probably, I think it's safe to say you're probably not familiar with what the actual accurate value of these hounds can be.
Right.
If I told you that my hound was worth $50,000, what would as a prosecutor, you're the prosecutor, you're looking at this case, my conversation with you is this hound is worth $50,000. Would you think that would be high?
Well, without knowing anything, I would think that would be high.
Okay, yeah. And this is just speaking general terms, and I think this is what we are up against as a hound hunting community, a hunting segment here, is that people don't realize that
how high they are. Now, when you were stating factors like stud fees and lifetime earnings, I could see how it could get to be that high.
The hounds, a lot of hounds, and this is, I'm not challenging you here, Aaron. I'm just saying this is what we're up against. If you talk about thoroughbred racehorses, I think that's a widely understood concept.
Sure.
That these horses are very valuable. But $50,000 in today's market is not uncommon.
Right.
And that's a shocker to just the general public. You run that by a judge, you run it by a jury, most people are going to be sitting back going, holy smokes, I didn't realize a dog could be worth that much.
And so one of the issues you're going to have when you get into numbers that high for restitution is inability to get that much money. Because, in reality, a lot of people don't have that kind of money where they can write a check for $50,000, right? And
that's a good point. Let's go into that.
So now you've gotten into a number that's kind of unrealistic for many people, and not all, right? You could be some guy who's got plenty of money and shot the dog and can write a check without blinking. But
that's the guy that worries me because he's not going to feel any remorse
he's
either.
Not going to feel any remorse, but
like,
at least you get your
$50,000,
$50,000, right?
Yeah.
But in most cases, you're going to get somebody who's not in a financial ability to get that. And that's why, it's like auto accidents. That's why you have insurance. Because the insurance is there, and, I'm sure there's not anything like that available in this world, but because most people can't afford to pay the damages. That's why if you're smart, you got a high underinsured and uninsured claim, because if you wreck into the person who's only got $25,000, you want to make sure there's enough money there to take care of your damages should you have the unfortunate of serious injuries or whatever resulting from an auto accident. So with that said, there's a pocket there that can take care of that expense. But if we didn't have, which is why there are requirements, if we didn't have insurance and didn't have most of the cases, we wouldn't be able to get the money because the judgment wouldn't be worth the paper it's printed on.
Right.
Because you still got to enforce a judgment, and that's kind of in the civil thing. So if, as a prosecutor, I'm demanding $50,000, then I can't. It's unlikely that I'm going to be able to get that. So you can get an order over a period of time for a certain amount. And
where they're basically making payments on their judgment.
Making payments. But it's unlikely, it's unlikely you're going to be able to get a full recovery of $50,000. So, but you want to be able to support that. If that's what you're talking about, that high a number, and if that's not uncommon, you would really need to sit down and prove that out to the prosecutor, because the prosecutor's got to understand where that's coming from.
I can just imagine. I can imagine how that conversation would go. If I was not familiar with the in-depth knowledge that I have with hounds, if somebody walked in and said, "Yeah, that hound's worth $50,000," I'd be like, bullshit,
Right.
Come on. You're trying to over-sensationalize this thing because you want your pound of flesh, and so now you've got the greatest dog that ever lived, and you want to take next year off of work, and
right.
Whatever it is. But the thing of it is, they're actually worth that much money, and so this is as much about having this discussion as much about preparing hunters to keep track of things like that, and
Sure.
to do a little bit of pre-planning, because every time you turn that hound loose, you could be encountering a loss on that.
Right.
So you need to know what those numbers are. You need to think about it now.
So, if it's $50,000, one of the things I'd want to see is people paying $50,000 for that dog, not just, this is an estimate.
Other examples.
Yeah, so here's a dog, just almost like a house, right?
Yeah,
it's comparables,
yep.
right? So
you can do comps on real estate all day long.
Right. So here's dogs this, and this is what they pay, right? And then again, I think lifetime earnings and stud fees are a very good indicator. Easy, hard math statistics that quantify into a monetary value, right? Lifetime, if a dog's 2 years old and's earned $10,000, it's understandable that it could earn a lot more.
Yeah.
Right?
Yep.
And if you're already getting, $500 stud fees for your dog at 2 years old, and I don't know what the performance range is for dogs, but then you have a comparable where you can point, look, it's a 5-year generally top performance level, so that's $50,000 here. That's it, and then you figure out present value. I mean, you get someone who really knows statistics; they can actually figure that out for you. But that would support. So when you go in and you say the dog's worth $50,000, and you go in and they go, what? And they say, well, here's this dog, this dog, this dog, and this is what I've earned, and this is what I'm getting on stud fees. That obviously supports that, right? Versus the dog you just bought, the puppy that you just bought for.
That you got high hopes for.
Right.
He's going to be the best one ever. I know he is.
And you don't get to make that argument, right? I mean, maybe it would have been the best one ever, but we don't know that yet, right? I mean, it's got to have proven itself to be worth that level of money. But if you can make the case, and the prosecutor has the information to support that, I mean, I would think the prosecutor would say, no, this is what we're dealing with, and try to get at least a judgment and some sort of requirement to pay on that.
Right.
So you could get to pay, because you do have the ability to get a judgment that would attach to any of that person's property through the restitution. A lot of times we would reduce restitution orders down to a judgment. And then as a condition of probation, they would be required to make payments towards it. And getting rid of the felony would be one way to get the money.
Yeah.
So
I think at the end of the day, people just want to be they just want to be treated with respect, and
Absolutely.
like they want what is fair and equitable. While your initial response may be you'd like to see the case be a capital punishment case, that's probably not realistic. So you have to be realistic, and a big part of it on the cases that I have been involved with on this is it is highly emotional.
Sure.
It is. I've been in a situation where we were squirrel hunting, and there was another person on the property that ended up shooting this dog, and at that time, it wasn't my dog. The owner of that dog was extremely emotional.
Sure.
I mean, they were fired up. And at the time I was working as a conservation officer, then I felt like it was my job. I had to be the peacemaker here. You go here and you take care of your dog and you get him to a vet. I will deal with this situation. I get it. It's going to be an emotional type thing. But the person who takes time now and has the information like you've given them today, and they can start, we never want to, hope you never have to use it, but if you can prepare in advance for this type of thing, then it doesn't rock your world quite so bad.
Right, and you do need to have the data to back it up. You can't go in and say, I think he made me 10,000. You know, you need to be able to point to the tournaments and the actual money you've received for stud fees. You know, because you got to have the data. But if you have data like that, then it supports a very large
and one of
financial value to the dog, clearly.
One of the things that we've got going in our favor is organizations like PKC. You know, they keep track of lifetime earnings, and then you have organizations like the United Kennel Club that keeps historical reproduction records for a particular dog. So that's why we have to be that's our resources to draw on. And then, of course, we know other people that have paid so much money for comparable, like you brought up, comparable hounds and stuff like that. Well, I want to touch real quick. We kind of took a long time there on the criminal side.
Sure.
Real quick on civil. Tell us what's different about civil law versus criminal law.
So first is the standard of proof is by preponderance of the evidence, which is 51%. So if we're putting a number, and I don't like to do that on beyond a reasonable doubt, but let's say beyond a reasonable doubt is 90% or higher, preponderance is 51%. So the standard is much lower.
More than likely he did it.
Right.
Yeah.
And then because it's a crime under criminal mischief, you could be entitled to attorney's fees, and you could be entitled up to triple damages. So you need to look at that to be certain, but that would be, civil crimes generally are entitled to attorney's fees and treble damages. You would want to review that and talk to an attorney about it. The downside is a lot of attorneys aren't going to take that on a contingent fee for the reasons we discussed is, well, I can sue someone and get $1 million judgment, but if they ain't worth $1 million, then that's not going to do me a whole lot of good.
Right.
So they're probably not going to do a contingent fee on it, because contingent fee means there's a likelihood that I get paid, and so because I could get nothing. You don't have to pay anything up front, but you got to take the risk. Mm-hmm. If the attorney's taking the risk, they can charge a higher percentage, but that presumes there's a pot at the end of the rainbow that I would otherwise get unless things go really bad.
Yeah.
So in all likelihood, I'm going to say I need some money.
I need a retainer.
I need a retainer, and that gets really expensive really fast, right? Mm-hmm. I mean, my hourly rate, which is probably low for Marion County, is like $300 an hour.
Wow. And we need to get this cut off pretty quick.
And that's not high for this area. I mean, attorneys at larger firms are, $1,000 an hour or more. So, and I say that just so people understand how expensive it is and how expensive it can add up really quick. And And so even at $250, it doesn't, at 4 or 5 hours in, you're into $1,000.
Right.
So that's kind of the prohibitive issue there, is either the person has a $50,000 dog that they're willing to write a check for $10,000 to pursue a lawsuit. But then what if the person has no assets, right? Or not substantial enough assets to pay the $10,000 that you eventually get? A $50,000 judgment that you paid $10,000 for, and maybe you get the attorney's fees, so maybe you're owed $60,000. But if the person doesn't have $60,000, then you have a piece of paper you can frame saying you got
you
justice.
Won. Yeah,
but
it's a participation certificate for a civil case.
Yeah, so I mean those are the downsides. Now look, sometimes you could run into someone with the deep pockets, right? And then that would certainly be worth pursuing. But in most cases, you're not going to run into the person with the deep pockets. So the criminal remedy is really your only remedy.
Yeah.
But, if they have a large piece of property, if they were hunting on their property and it's a large piece of property, it might be worth pursuing something to get some sort of judgment. And you could even go, if it's not a $50,000 dog and it's a $3,000 or $4,000 or up to $8,000 dog, you could go to small claims court. You don't have to pay an attorney anything. And you could just sue in small claims court and get a judgment attaches to his property or her property, and then you can, at some point hopefully get paid on that.
Gotcha. Well, I think this has been helpful, and I'm sure there's a lot more information, but we want to start it out right here. It's the season for it. It seems like a lot more people are going to be out hunting and things like that. I thought we'd close out the podcast with we'll play a little drinking game here. I'll tell any attorney joke that I start that you can't finish, then you have to drink. And any game warden joke that you start that I can't finish, then I have to drink.
I don't know any game warden jokes.
Oh, you...
I don't. But you go ahead and give me the attorney joke, and I'll tell you that. I'll see if I know the ending.
We'll say, you serious?
Yeah, go ahead.
Do you know why? I don't know if I can tell that one on the air. We better do this off air.
Well, I'll end with this attorney joke. All right, so there was an attorney, a doctor, and a lawyer. No, a lawyer, a doctor, and a minister, and they were friends of this really wealthy, eccentric fella. And he gave each of them $1 million in cash and said, when I die, I want you to bury me with the money. And so he said, okay. They all said, okay. And then a little while later, the old man dies. And he's buried, and the casket is presumably filled with, everyone's there. It's filled with money, just as he wanted it. And he gets buried, and, they're at the wake, and the three of them are talking, and they each knew that he had done this with each other. So they're sitting there talking, and the doctor says, hey, says to the minister, did you really put all $1 million in the casket? And the minister says, well, I have to confess, I kept $200,000 for the soup kitchen, but I did put in, the rest. And the doctor said, well, good, I feel better. The children's wing, the cancer wing needed some money for some new equipment, so I put in $500,000 for that, but I put in $500,000 cash in the casket. And so then they asked the lawyer, did you put all of the money in? And the lawyer said, absolutely. I wrote him a check. So anyway, we'll leave it at that.
All right, Aaron. Hey, thanks a lot, man. I appreciate you taking your time and helping us out on this. And can't thank you enough.
All right.
It's always been a pleasure.
It's been fun.
Yeah.
It's been great.
Thank you very much.
Thanks for having me. Bye.